Louis, good afternoon.
Jess, how are you?
Fine, thank you. What do we have for a reset date?
It is going to be, good afternoon, Your Honor.
Bridgewater.
It is
Yes.
going to be March the 4th.
All right, moving up the calendar. All right, thank you. Okay, good afternoon, ladies and gentlemen. My name is Judge Lal, and this is going to be our expedited accusation calendar with the State Court of Fulton County. This is essentially a first appearance calendar for individuals who've been recently charged and booked at the Fulton County Jail. The charges brought against them are misdemeanor offenses. This would be your first appearance before a judicial officer. Well, I will advise you of what is your new case number, what are the charges brought against you, to appoint counsel to represent you if necessary, and to also set a bond. For some of you, you may also receive a new court date of March 4th, 2025 at 9 a.m. And the calendar on that day, March 4th, will also be a virtual proceeding. So those who plan to attend will need a Zoom link to be present. If you're a defendant charged with a misdemeanor offense or offenses, please remember that you have a right to remain silent. Anything you say during the course of this virtual proceeding that's not only being recorded but live streamed, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. With regards to bond, we will be looking at the charges brought against you, the circumstances surrounding those charges, as well as to see if you have a criminal record history. Based on some of these factors, you may be qualified for what we call a signature bond, in which you would not have to pay for the bond today, but you would have to comply with certain conditions in order to preserve your signature bond. Otherwise, others may receive what we call a surety or good bond, where you would have to pay for the bond either out of your own pocket or through a bonding company. All right, courtroom 2, who shall we begin with?
We'll go in position number 17, Ms. Ramirez.
All right.
First arrest.
Thank you, Mr. Howard. This is Ashley Ramirez Dietrich, accused of simple battery family violence from February 17th of this year. Accusation 25 CR 853G. Ms. Ramirez, you've been advised of your right to remain silent. Your attorney is going to be Mr. McLean. And this is the first arrest. Ms. Allen, any recommendation?
Yes, Your Honor, we're asking for a $2,000 signature bond through pretrial, no contact, no drugs, alcohol, or weapons. And we would ask you to sound for the victim, who is her mother. This is an incident from the 17th of February. Sandy Springs Police responded to 8601 Roberts Drive at about 4:40 p.m. They spoke with the victim. Her name is Melissa Dietrich. She's the mother of the defendant. She reported that she and her daughter had gotten into an argument, that arguing is an ongoing issue, that her daughter's juvenile son with initials AH had become upset while mom was arguing with him over a cell phone. Grandma intervened, and this upset the defendant, her daughter. In response, the defendant in front of you struck her mother, and she called the police and made a report. The defendant had left at that point. She was just picked up on the 17th. And this incident occurred in the home where they both live, Your Honor. So we would ask for you to call for Mrs. Dietrich. She says that she believes there's a substance abuse issue, that the defendant, her daughter, and juvenile child live in the home with her. He attends school, and I think she'd like some help for her daughter. Thank you.
Melissa Dietrich, if you are present, you would need to unmute and start your video. All right. All right. Dietrich, you probably need to have the audio connected to your device.
Okay.
There we go. Be good. All right. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. So the prosecutors asked that Ramirez, your daughter Ashley, basically be not allowed back in the home and to stay away from you. Would that be correct?
Not necessarily. She has an alcohol problem and she's had it for years. And things have gotten worse in the past couple of years since the accident when she lost her leg. And she's gone to outpatient rehab before for the alcohol and so forth, and it only worked temporarily at an outpatient basis. And
So one thing is that's one thing, but that still doesn't address my other question. Are you comfortable with her being in the same home with you?
yes,
And are you comfortable with having contact with her?
yes.
All right. Mr. McLean, anything else to add?
Your Honor, yes, the home has been outfitted for her physical condition right now with the walker and everything and the prosthetic device. So we have no objection to them staying in the same home, no further violent contact, and the signature bond, Your Honor. Thank you.
So, Your Honor, just based on information from Mom, we'd be asking for a evaluation and to follow through with any treatment, no violent contact. When we spoke to Mrs. Dietrich, she did inform us that she was in fear and that these issues with anger and violence have escalated recently.
Thank you. Ms. Ramirez Dietrich, I'm going to grant you a signature bond. Now the question is whether you're allowed to go back home with Mom or whether you're going to have to find your own place. At the present time, your bond's going to be set at $2,500. It's going to be a signature bond through pretrial services, level 1. You're to have no further violent contact with Melissa Dietrich, and you may return to the home at Roberts Drive, or if you choose to vacate and move into a different place, you'll be required to update the court of your new mailing address immediately upon changing your residence.
That's my apartment in my name, so
Does your mother live there?
she moved in with me after
Then she's a resident. And if you don't want your mother there, then you would need to file an eviction case against her.
That's what I was gonna ask. Thank you.
All right. But in the meantime,
Yes.
within 10 days of being released from the Fulton County Jail, you will go to a qualified healthcare provider and undergo an alcohol and drug evaluation and submit yourself to any treatment or counseling and so forth as required, as well as to any random screens that they may require.
No problem.
You are also to enroll in a domestic violence intervention program. This is a 26-week program, and you're going to have to pay for those classes out of your own pocket. By your second visit with pre-call services, you must show proof of enrollment in the domestic violence intervention program. No illegal drugs, no alcoholic beverages, and you will be subject to random screens by pretrial services. So pretrial can call you randomly to submit to a drug or alcohol test. And if you fail to do so, that would be grounds to revoke your signature bond and have you arrested again so we can amend the bond to a surety bond. Do you understand? No further violent contact means that you can return and cohabitate with Melissa Dietrich. And if there are any future physical or verbal altercations where the police get involved again, you will be arrested and brought back to jail with no bond or a cash or surety bond. Your next court date will be sent to your current mailing address. Like I said, if you change your address, you need to let us know within 30 days of changing it. Thank you.
Thank you.
Position number 5, Ms. Davis is negative.
Position number 5.
I'm gonna have to go this way.
All right, Mrs. Dietrich, you can leave the Zoom, please.
Okay.
Thank you. Is this Chloe Davis?
Yes, Your Honor.
All right, your case number is 25 CR 861A, accused of simple battery family violence from February 18th, 2025. Ms. Davis, you've been advised of your rights, and your attorney is Mr. McLean, or is it Ms. Pinto?
It's me, Judge.
Thank you. It's Ms. Pinto. And any priors, Mr. Howard?
History out of Virginia, Maryland, Pennsylvania, North Carolina. 2024 FTA. Got an open retail theft and theft by receiving case. Open case for, what is this? Petty larceny, identity theft, simple possession of a Schedule II controlled substance, and FTA out of North Carolina. Open grand larceny out of Virginia.
All right. Ms. Mukeke, good afternoon.
Good afternoon, Your Honor. The victim in this case is Mr. Devil Swilling, who shares a child with the defendant. Officers were flagged down by security at the Lindbergh MARTA station after an altercation. The victim told officers that the defendant had pushed his cell phone into his face and also showed them a video depicting the incident. Our office has spoken with Mr. Swilling, who states him and the defendant are not in a relationship. They do not live together, but they do share one child. He has custody of the child, and the defendant has supervised visits. They met up at that MARTA station so that the defendant could see their child. He told the defendant he had to leave because their son had track practice. The defendant asked if she could come, and when the victim said no, she got upset and began grabbing at the child. The victim pulled out his phone to record, and that's when the defendant grabbed the phone and mushed it into his face. The victim tells us this is not the first time the defendant has been violent towards him, but this is the first time police have been called. He wants no contact with the defendant and wants her to stay away from his residence. I'll send that address to Ms. Bridgewater in just a moment. The state's recommendation, given her history, including her FTAs and open cases, is $1,000 surety bond, no further contact with the victim, stay away from the victim's residence, that she undergo some anger awareness, no drugs, weapons, or alcohol while out on bond. And I would ask the court to sound for Mr. Swilling.
Cavell Swilling, if you're on Zoom, this is the time to unmute and start your video. All right, Mr. Swilling, you're in a courtroom. You'll need to remove your hat. All right. Raise your right hand if you want to say anything. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. And so you have primary and sole legal custody of the child in question?
Correct.
All right. And you do not share a residence with Ms. Davis, correct?
Correct.
All right. Is there a parenting plan in place between you and Ms. Davis?
Yes. So I have physical custody, and as far as supervision, like as far as visitation for her, it's to be supervised.
Okay. And who supervises the visitation?
I'm guessing I would be the one that supervised.
All right. All right. Thank you so much. Ms. Pinto, what's your response?
Yes, thank you, Judge. Ms. Davis is 32 years old. She's lived in Atlanta for about 2.5 years. She does have family who live here as well, including her brother, grandmother, mother, her children. She's currently at the Paul Mitchell Hair School. She has about 67 hours left of that. So that's further ties to the community. She is okay with no contact with the alleged victim in this case. I would ask that if there is a way to do third party supervised contact with the child, since I do understand that apparently those visits have to be supervised, but she can do no contact with the alleged victim. I understand that she did have a failure to appear that was addressed by pretrial. She does report that she had been previously incarcerated and received some failures to appear while incarcerated or while having surgery. So I'm not sure if that was actually a willful failure to appear. For a bond, I understand that she's been, by pretrial, she's recommended a UJR level 4. So I would ask for a signature bond.
A bond is set at $1,000 surety. Unfortunately, Ms. Davis is a multi-state offender with a recent failure to appear, which disqualified her from a signature bond under Georgia law. She's to have no further contact with Devell Swilling at the present time. They may still exercise their parenting plan, but supervised visitation must take place with a third party. So, Mr. Swilling, if you have a friend or a family member who's willing to monitor visitation with Ms. Davis in accordance with the parenting plan, that would be your option. No illegal drugs, no alcohol, no weapons, and her next court date will be March 4th, 2025. Thank you.
Next is position 14, Ms. McAfee.
This is State versus Aja McAfee or McPhee, accused of simple battery family violence from February 18th, 2025, accusation 25 CR 852C. Ms. McPhee, you've been advised of your rights and your attorney is going to be Ms. McLeod. Do we have a cross defendant in this case?
Yes, it's here.
And position number?
1, Your Honor, Mr. Banks.
If Mr. Banks wants to come forward as well. This is Cortez Banks, case number 25 CR 857Y. Mr. Banks is charged with battery family violence from the same date, accusation, and they are both cross defendants from the same incident. Mr. Banks, you are represented by Ms. Pinto. Any priors on Mr. Banks, Mr. Howard?
2nd, 2023, suspended license, no low. He got an FTA warrant out of Conyers. McPhee, 2023, battery DV, cruelty, that was dismissed.
Thank you. Ms. Mokeke, if you want to address both cases, please.
Your Honor, for Mr. Banks, the state's recommendation is going to be a signature bond, no further contact with Aja McPhee. I will defer to the court regarding a stay away. We'd also ask for no drugs, weapons, or alcohol, that he undergo anger awareness or an FVIP. Mr. Banks is accused of striking the victim in her face, causing a bleeding laceration to her chin and upper lip. He told officers that he hit Ms. McPhee because she was kicking and punching him. Ms. McPhee told officers, according to the warrant, that she fell and that the defendant never hit her.
All right.
And Your Honor, I prepared Mrs. McPhee's case.
Go ahead.
The only additional information I'd add is that she did have to go to Grady to receive treatment for the injuries that were obvious on her face when police made contact with her. The 911 call in this case was made by an unrelated third party who reported that they observed a male beating a woman on the side of the road, and police did encounter these folks on the side of the road. They reported that they lived together. We'd be asking for a $2,000 surety for Mrs. McPhee based on the prior that is pretty recent. Again, no contact and no drugs, alcohol, or weapons. And I guess this is Ms. McLeod's case. Good morning, Ms. McLeod.
Good afternoon, Ms. Allen. Your Honor, I would ask for a signature bond for my client. My client tells me that she is a therapist. She has no record at all. An arrest is clearly not a conviction and does not prove one is guilty of anything. And I believe the pretrial said that the previous arrest, that was resolved by dismissal. So I think she does qualify for signature bond, Your Honor. I would ask the court to give her that.
Does your client live in her own home?
Yes, Your Honor, she does. I believe she told me they did not live together, but maybe the state has some separate information, but she told me that she lives with her child.
Which city does she live in?
She lives in Stone Mountain, Your Honor.
Okay. And Ms. Pinto, what about your client?
Thank you, Judge. So it was my understanding, well, he would like to have contact with Miss McPhee. Of course, I don't know how Miss McPhee feels about
She
that.
would like to have contact with him as well. No further violent contact is what she would prefer.
Yes. We would echo no further violent contact. And we would echo the state's request for a signature bond.
On both cases, it's going to be a 2,500 signature bond through pretrial services, level 1. Both parties are required to undergo a domestic violence intervention program within 30 days of being released. So both of you can sign up for your bond. It's 2,500. No violent contact with regards to both of you. So both of you are not, well, if you are certain you can cohabitate or deal with each other, great. But there cannot be any future physical or verbal altercations between the two of you. Otherwise, the police will arrest both of you and then ask questions later. And your signature bond could be revoked as a result of a subsequent arrest. But in the meantime, if you do, once you both make bond on this signature bond, you both report to pretrial once a month. No illegal drugs, no alcohol, and no weapons. And as I indicated, within 30 days of being released, you will also enroll in a domestic violence intervention program. And both of you will attend classes together. It's a series of 26 classes, and you can either do it together or you can do it separately, but each of you must complete the 26 classes at your expense. If either of you decide that you don't want to live together or something like that, then within 30 days of changing your address, you need to let us know of your new address. We will send you summons for your next court date. Failure to appear can also result in a bench warrant for your arrest. Okay? Thank you.
Thank you, Your Honor. That concludes my business before the court today. May I be excused?
Yes, thank you.
You're welcome.
Okay.
Good afternoon, Judge. This is going to be position number 8, Ms. Higgins.
Okay. This is State versus Lashana Higgins. And Ms. Higgins, as well as the other lady sitting at ACDC, my name is Judge Law. I'll be addressing each of your cases on a one-on-one basis. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Ms. Higgins' case number is 25 CR 864D, and she's accused of battery, family violence from February 18th, 2024. Your attorney, Ms. Higgins, is going to be Mr. McLean. Any priors, Mr. Howard?
Second, 2015 ag assault dismissed.
Thank you. Ms. Mulcahy?
Yes, Your Honor. The victim in this case is Braylon Hamilton, who is the defendant's son. The defendant is accused of hitting her son with a stick, causing bruises to his hand. The defendant told officers that her son smokes and doesn't go to school, is unruly, and she wanted him out of the house. The victim told officers the defendant came into his room and they started arguing, with her telling him that he needs to move out the house, and then she proceeded to strike him with that stick. The defendant's daughter, a minor with the initials ZH, stated that she saw her mom go into her brother's room with a wooden stick. The victim in this case is 17 years old. The state's recommendation for Ms. Higgins would be a signature bond, that she undergo an FVIP, that she have no further violent contact with any of her minor children, and that she have no drugs, weapons, or alcohol while out on bond.
Any objection, Mr. McLean?
Your Honor, she is awaiting a job. I mean, she has a job that is starting soon, this week, I believe, in patient care. And before that, she worked in the physical plant at Grady Hospital. I don't think she's going to be able to afford the 26-week DVIP. And I wonder if it would be possible to do something smaller.
All right. When is Braylon's birthday? When does he turn 18?
Ms. Higgins, when does your son turn 18?
September 9th.
What?
September
September.
9th.
September 9th. So until then, he's considered a minor. And he is still your responsibility. Unfortunately, if you have a certain idea of what we call corporal punishment, in other words, to discipline your child, clearly using this method has landed you in jail. So maybe that might not be the appropriate method. Your bond is going to be set at $2,500. It is going to be a signature bond through pretrial services, level 1. You can sign up for your bond, but you are to have no further violent contact with Braylon Hamilton. Please keep in mind that he's not 18 yet. Until he reaches the age of majority, he is a parent's responsibility unless he emancipates himself. But until then, no more corporal punishment, no more disciplinary methods, no more physical and or verbal altercations between you and Braylon or any other child that lives in the home with you. And within 60 days of being released, you're to enroll in one parenting class that you would need to complete at your expense. You report to pretrial once a month, no illegal drugs, no alcohol, no weapons, and no firearms. Next court date will be sent to your address. Thank you.
Next judge is going to be position number 9, Ms. Ford. She did have a private attorney. She was on the felony calendar, but he's not able to attend, so she chooses to go pro se.
This is, I'm sorry, what position number is that?
Position number 9.
9. Ms. Carolyn Ford is accused of theft by conversion from December 14th, 2024, under case number 25 CR 865F. Ms. Ford, you have been advised of your rights. What is the name of your attorney?
Dennis Shive.
And Mr. Shive is not representing you for this hearing?
No, ma'am.
And will he be available tomorrow?
I'm not sure at the moment. I can reach out and see.
Because the public defender's office will not represent you if you already have an attorney representing you. And I cannot proceed with your case if you have an attorney representing you because.
I want to go pro se, please.
Are you waiving your right to counsel today?
Yes.
And you understand that if you waive your right to counsel, that you're responsible for all legal decisions and you are charged to know the issues with regards to the criminal laws and procedures and how they apply to the facts of your case. Are you still prepared to move forward?
Yes, ma'am.
All right then. So you know you're charged with theft by conversion from December 14th of last year. Mr. Howard, any priors?
4. Got an open ag assault, possession of a firearm out in Superior Court. It's 25 SC 000722. Went to felony earlier for ag assault, possession of a knife or a firearm during the commission. It's 25 PI 001 308. That was no bond. And a 2024 DUI arrest.
All right. Ms. Mulcahy?
Yes, Your Honor. The defendant was driving for the courier service roadie and was supposed to be delivering a set of AirPod Max Pros valued at $529 to an individual located at 990 Hammond Drive in Sandy Springs. However, the defendant never delivered the item. Security footage of the location showed that the defendant never exited her vehicle to deliver the item, and she kept changing her story when officers questioned her about the incident. She currently has a $600 surety bond. I would ask that that remain the same given her history, which does include some open cases. No driving or doing deliveries for that roadie services for the time being. No drugs, weapons, or alcohol while out on bond.
Ms. Hoard, this is the prosecutor's recommendation that your bond remain at a $600 surety, and that presently you do not work with Rhodey and you stay away from the Hammond Drive location. You have a right to remain silent. Anything you choose to say can and will be used against you in the prosecution of this case or any other open cases you have. Would you like to exercise your right to remain silent, or do you have an argument for an alternative bond?
I'm fine.
Okay. Bond is set at $600. It is a surety bond to stay away from 990 Hammond Drive in Atlanta, Georgia, and to not be associated or be employed by the Rhodey Company in terms of delivering to any private or commercial residences. Next court date will be March 4th.
Oh, Your Honor,
Yes, sir.
number 10, Rashad Hughes, I don't believe it's been interviewed, and I believe number 16, Kamaya Mitchell, has not been interviewed.
All right, let's see.
Judge, I did interview Mr. Hughes.
Oh, good.
All right, so position 16 has yet to be interviewed?
Right, I believe that's correct. So if one of us is doing one case, the other could be interviewing on the telephone.
All right, thank you. Deputy Francois, do you have any other cases with us?
No, that's it. Thank you, Judge. Have a good one.
You too, thank you. Courtroom 2, who do we have, please?
Number 6, Ellis Wallace.
All right, is that Miss Pinto's case?
Yes.
All right, Miss Pinto, we're going to address position 6. In the meantime, courtroom 2, is Kamaya Mitchell available?
We don't have her.
Okay, so Mr. McLean will have to hold off until she's available.
Thank you.
Position 6 is Brandon Ellis Wallace, 25 CR 862H, accused of battery, family violence from February 17, 2025. I understand this is his first arrest.
No, it's that 13.
Oh, 13. Okay, I must have written it down the wrong one then. 13 cycles?
Got an open case out of Savannah for obstruction, disorderly conduct. Another open case for suspended license on probation in Fulton for theft by taking. It's 22 SC 181407. Wanted out of McDonough. 2022 probation, 2017 probation FTA. 07 robbery first offender.
Oh, what's the year of the FTA? I'm sorry.
17.
Okay, thank you. Miss Mulcahy?
Yes, Your Honor. This incident occurred at 673 Kennesaw Avenue in Atlanta. The victim in this case is England Cutler, which, according to the citation, lives with the defendant. The defendant is accused of striking the victim on her legs with a closed fist, causing bruising to her leg. The state's recommendation, given the allegations and the defendant's history, is a $2,000 surety bond, no further contact with the victim, stay away from the incident location so long as the victim is living there, no drugs, weapons, or alcohol while out on bond, and that he undergo some anger awareness classes or an FVIP. I would ask the court to sound for the victim in this case, Miss England Cutler. Our office has not been able to get in contact with her.
England Cutler, if you'd like, if you're present, I'm trying to see whether there's anybody else here. England Cutler, no. Miss Lewis, we can remove Dobell Swilling. He's no longer required for this calendar. And all right, no Miss Cutler. Anything else, Miss Mulcahy?
Nothing else, Your Honor.
All right, Miss Pinto?
Thank you, Judge. Mr. Ellis Wallace is 37 years old. He's lived in Atlanta almost his whole life, so he has very strong ties to the community. The majority of his family lives here as well. He has 4 children. Prior to this arrest, he was working at the mayor's office doing security. He's been there since November. So we are concerned about him potentially losing his job over this. I would ask for $1,000 surety bond. And if the court wants to impose classes, I would ask for the anger awareness over the family violence class due to the cost and the fact that he may be unemployed. He does have another address he can reside at in Ellenwood, Georgia, which is the address that's on file. He's okay with having no contact with the alleged victim. We would just ask for a one-time return with law enforcement for him to retrieve any belongings.
This is going to be a $5,000 signature bond for pretrial services, level 3. No further contact with England Cutler, which means he has to stay 200 yards away from Miss Cutler, as well as from the Kennesaw location, the 673 Kennesaw location. He's allowed a one-time visit to that location with a police officer. That visit cannot exceed 1 hour, and he has that 1 hour to retrieve his personal belongings. He is to enroll in a domestic violence intervention program. This is a 26-week program, and he's to attend and complete all 26 classes at his expense. He's to report to pretrial once a month. He must update the court with his new mailing address in Ellenwood within 2 weeks of being released. No illegal drugs, no alcohol, no weapons, and no firearms, and he will be subject to random screens. His next court date will be sent to his Ellenwood address as long as he updates us with it. And if he gets arrested again for anything else, his signature bond of $5,000 will be converted to either a $5,000 cash bond or a surety bond. Thank you.
Hold on. You said level 3, right?
Level 3, yeah.
So he need to report once a week, not once a month, and this per judge too.
Once a month? I'm sorry, I meant once a week.
Okay. This per judge, Holly.
All right.
Position number 15, Mr. Mills.
This is State versus Donnie Mims, accused of driving under the influence of alcohol and possession and use of a drug-related object, July 12, 2023. Mr. Mims, the accusation is 25 CR 866C. You've been advised of your rights, and your attorney is Mr. McLean. Any priors, Mr. Howard?
30. He got an open case out of Henry and Butts County for forgery in the first. On probation in Jackson County for forgery in the second. 2024 probation, 2023 DUI.
Which would...
I think he went to the city jail for that, so I don't know if it's been bound over yet or what.
This is that case. It's a 2023 bind over. He failed to appear as part of his DUI case in municipal court, Your Honor.
Understood. Okay.
He's got a $3,000 bond. We're not asking for that to be increased necessarily. He does have prior history. He has not been licensed since 2023. We're asking for his bond to be a surety bond, for him not to drive and have no drugs, alcohol, or weapons. We'd also request that he be subject to random screens. This is a case that occurred. Police were actually called to the gas station at Exxon 3160 Greenbrier Parkway by a 911 caller not related to this defendant. They reported that someone was unconscious there at the location, and when police made contact with the defendant, he was slumped over in his vehicle, parked at a pump. He admitted he'd had alcohol, and he admitted he'd driven there. They had to wake him up. He had an open container, and he had a glass pipe in his possession there as well. So with that, that's an issue, Your Honor. It's a public safety issue. He's got prior similar convictions and at least 3 open cases he's being supervised for or out on bond for.
DUI related matters?
No, but drugs and theft and forgery and prior drugs and DUI.
Mr. McLean?
Your Honor, thank you. Donnie Mims is 51 years old. He has a Bachelor of Arts in sociology from Georgia State. He is from Georgia, and he has a Lithonia address, which is the same as what's listed in the PSA. with these community contacts and with this case being from 2023, we would ask the court to consider a signature bond, but realizing it is a DUI. If that's not in the offing, then we would ask for as low a bond as possible, such as 1,000 or 1,500 surety.
Okay, thank you. On the driving under the influence of alcohol and or drugs is going to be 2,000 surety. And the drug-related objects is a $2,000 signature bond through pretrial services, level 3. It's a $4,000 split bond. Next court date is March 4th, unless he makes bond. Once he makes bond, he'll need to report to pretrial once a week. He'll be subject to random screens for illegal drugs and alcohol. He's not allowed to drink any alcoholic beverages and not to consume any illegal drugs, including marijuana. He's also prohibited from driving unless he has a valid Class C driver's license. If he has a limited permit or temporary driving permit from the Department of Driver Services, that does not qualify. It must be a valid Class C or a commercial driver's license that he has in his possession, and the vehicle that he operates must have adequate insurance and proper registration. Your next court date will be March 4th. Thank you.
Number 18, Williams.
Eric Williams is case 25 CR 854B, accused of battery, simple battery, and criminal trespass. The alleged incident date is February 18th of this year. Mr. Williams, you've been advised of your rights, and your attorney is going to be Mr. McLean. Any priors, Mr. Howard?
24. His last arrest was felony obstruction, simple assault. That was DWAP 2023 and 2022 probation. He had some ag assault arrest that was dismissed. 2020 obstruction conviction, probation. 2019 4 counts of simple assault conviction. 2018 probation, felony obstruction conviction. 2016 forgery in the 4th conviction. 2016 and 15 parole violation, came off of 07 armed robbery conviction.
Thank you. Ms. Allen?
Thank you, Your Honor. I would note that in October of 2024, this defendant was arrested for felony obstruction and simple assault, and that was related to an incident at the Spondivitz restaurant in East Point. That's 1219 Virginia Avenue. That case was just dismissed. He was released on bond in that case in Superior Court in December, and the case was actually dismissed January the 15th. And that's important, Your Honor, because the case in front of you today takes place at the same location, 1219 Virginia Avenue. At about 1 in the morning, police were called there yesterday, the 18th. They responded when they were called by the manager. His name is Courtney Jones. He reported that there was an individual there refusing to leave, and police encountered the defendant at the location. He'd brought his own food and alcoholic beverages inside, sat down and was helping himself to his meal and his drink, and refused to leave after being asked multiple times. He had already been criminally trespassed previously last year as part of that other case. In addition to being asked multiple times on the 18th to leave and refusing, when the manager blocked him by closing the door to the bar area, the defendant became angry because the door made contact with his ankle, and he proceeded to punch the manager in the face multiple times and then use his fingers to aggressively push against the eyeballs of this gentleman, Mr. Jones, causing busted blood vessels and bruising to his face. There were multiple witnesses there, Your Honor, and police saw the obvious injuries to this gentleman. We've spoken to Mr. Jones, who's the manager and the victim of this incident. He says that he has encountered the defendant previously in the past, but this is the first time he's experienced an issue with him. He's concerned that there's an MH issue. He's requesting no contact and for the defendant to stay away. He's already been ordered to stay away from that location, Your Honor. We would request that same order today. We're asking for a $6,000 surety. Absolutely no contact with Mr. Jones. And we'd request a social worker visit or an MHET if that's appropriate, and some medication compliance if that's appropriate, Your Honor. Thank you.
McLean?
Your Honor, there is a portion in which I would ask us to go into a breakout session to discuss that portion that the state has already mentioned with specifics.
Ms. Lewis, can you place Ms. Allen, Mr. McLean, and myself in a breakout, please?
Will do.
Thank you. All right, getting back to Mr. Eric Williams. Mr. Williams, we had to discuss your case with your attorney who was advocating on your behalf. Given your criminal record history, given the allegations set forth in this particular case, as well as the fact that this is your second time being arrested at the same location within a short time frame, your bond is going to be as follows. On the battery is $2,000. On the simple battery is $2,000, and the criminal trespass is $1,000. This is a $5,000 surety bond. You are to stay 500 yards away from the Spondivitz restaurant at 1219 Virginia Avenue. You're not allowed to return there any time of the day or night, and you're not allowed to be in his parking lot, near the sidewalk, in the restaurant, and you're to have no contact with Courtney Jones or any of the employees working there. No illegal drugs, no alcohol, no weapons, and you will have a social worker visit. No illegal drugs and alcohol, and you must be compliant with any and all medical treatment and medication that is prescribed for you. We will see you on March 4th. Thank you.
position number 3, Burke.
Okay.
Yes, I know he can.
You're ready. Do you have a seat? He's talking to him.
This is State versus Andrew Burke, accused of criminal trespass from February 18th this year, accusation 25 CR 859E. Mr. Burke, you've been advised of your right to remain silent, and your attorney is going to be Mr. McLean. Ms. Pinto. Any priors, Mr. Howard?
I got an open case out of state court for disorderly conduct. It's 22 CR 007 665E.
Thank you. Ms. Mokeke, anything to add?
Yes, Your Honor. This incident happened at 125 Milton Avenue, Southeast Atlanta. That is the Verge apartment complex. The defendant is accused of staying on the property after being asked to leave by the property manager. The leaseholder, who is the defendant's mother, stated that her son was not supposed to be there and the apartment was supposed to be empty. The state's recommendation for Mr. Burke is a signature bond, stay away from that incident location, no drugs, weapons, or alcohol while out on bond.
Ms. Pinto?
Thank you.
Not granting a signature bond, but so it's going to be $1,000 surety, and we're going to have both cases reset to SAP. Anything to add?
Well, yes, Judge. So Mr. Burke was paying rent at the location. So I understand the warrant alleges that his mother says he was not supposed to be there, but I just want to note that he was, a legal tenant. He was paying rent. This sounds more like an illegal eviction to me. He did provide an Xfinity bill to the officers or the officer that resided at the location. He is 43 years old. He's lived in Atlanta for about 40 years. He has very strong ties to the community. So we would ask the court, we would echo the state's request for a signature bond. I understand that he does have one open case for disorderly conduct, but he is, of course, innocent until proven otherwise on that, Judge.
Understood.
Oh, I'm sorry. We would, if there is a stay away, we would ask for a one-time return with law enforcement to retrieve belongings.
Just 1 second. He's got a bond forfeiture. Or was reset? Okay. On the criminal trespass is going to be $1,000 surety to have to stay away from 125 Milton Avenue, the entire complex, which is the Verge apartment complex. Both cases are going to be reset to March 4th, and that would be this new case as well as 22 CR 007605E. Just one thing I wanted to, no illegal drugs, no alcohol, and no weapons. And that's it. We'll see him on March 4th. Courtroom 2, please unmute. Mr. Burke, you've been advised of your right to remain silent. Anything you say in open court, your statements can and will be used against you.
Yes, ma'am. Can you hear me?
Yeah.
Okay. At this current time, I was going through a evictions process with the Verge because my mother, she paid up for the first year for me to live there. I was the only occupant in that studio apartment. Afterwards, I was supposed to be able to turn it over into my name and keep paying rent there. I lost my job towards the end of the lease. And basically, currently, right now, I'm going through the evictions process, but my evictions hearing is been pushed to later on, the beginning of next month. I was under the impression that how could I be a person that's not supposed to be there if I'm still going through the evictions process?
I don't know, sir. I don't know all the facts of the case. All I have is a warrant that says that you were trespassed from the property and that you are allegedly there without the owner's permission.
Well, yeah, that's my mom. She doesn't even know that I'm in jail right now. And the thing is, my mom's not the one that's like, basically evicting me. It's the apartment complex. So, and if I'm like already proof that I'm a resident, why are they like, why does my mother's testimony mean anything at all?
I guess once you have a preliminary hearing with the division judge, then all this can come out to be. But right now, the allegations are that you're a trespasser, and we're going to address both your cases on March 4th.
Do I have to stay in jail till March 4th?
No, you can make bond. It's $1,000 surety bond.
I don't have a place. I don't have anywhere to go besides back to my apartment.
No, you're not allowed back at the Burge apartment complex until further order of the court. You are allowed a one-time visit to the apartment to retrieve your personal belongings, and that visit cannot exceed 1 hour. You can only go there with a police officer and leave with a police officer within 60 minutes. You're not allowed to stay there or be anywhere there.
So, and even if they illegally had me removed, like false, like they had me illegally put out of my home.
Well, the question is assuming facts that I don't know, because I don't know whether it's legal or illegal. Right now, I have a warrant that says you were there illegally.
But I provided the officer with sufficient enough information that said I was a resident.
A judge has signed off on the warrant. There's probable cause that you are not a legal resident of the location.
Okay.
Thank you. Your case is reset to March 4th.
Position number 4, Mr. Marcus Craig.
This is State versus Marcus Dwayne Craig, case number 25 CR 860C. Mr. Craig, you've been accused of battery, family violence, 2 counts from January 3rd of this year. You've been advised of your right to remain silent. Your attorney is Ms. Pinto. And Mr. Howard, any priors?
5th, 2022 battery DV dismissed. 2018 simple battery DV dismissed. 2014 battery dismissed. 2014 simple battery trespass dismissed.
Thank you. Ms. Mulcahy?
Yes, Your Honor. This incident occurred at 1225 Fairborn Road in Atlanta. The victim in this case is Lakeithia Pinkney. The defendant is accused of striking the victim in the face multiple times, leaving bruises and lacerations to her face. The victim told officers that they were arguing about her being a stay-at-home mom, and she was also fatigued in dealing with postpartum. The victim told the defendant she was going to faint or pass out, and he somehow took that as a threat and started to assault her. The defendant told officers that he had been assaulted by the victim and had 2 fresh stab wounds, and that he had initially withheld this information from officers because he didn't want the victim to get in trouble. However, officers did not issue a warrant for the victim because there was not sufficient evidence to support the allegation that she had stabbed him. Our office has spoken with Ms. Pinkney. She confirms her and the defendant are in a relationship. They live together at the location and they share 4 children. She confirmed the events in the warrant, stated that nothing like this has happened before and they have been living together since this incident and there has been no violence. She states she is not in fear of the defendant and wants to continue contact. The state's recommendation for the defendant, given his history, which every arrest includes an instance of violence, so there is a concern for the safety of this victim and their children, is a $3,000 surety bond, no further contact with the victim, stay away from the incident location, that he undergo an FVIP, no drugs, weapons, or alcohol while out on bond. I would ask the court to sound for Ms. Lakeithia Pinkney.
Ms. Pinkney, I do see you that you're on Zoom, at least the Zoom panel. If you want to address the court, did you want to say something?
Well, they pretty much said everything that I wanted to say, but
You could raise your right hand if you want to say anything. I'll need to place you under oath. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
yes.
So, Mr. Craig has had quite a few cases involving battery or simple battery, which were dismissed. Were you involved in any of those cases?
No, ma'am.
All right. And you share 4 children with him?
Yes.
How old is the youngest and how old is the oldest?
The youngest is 3 months. The oldest is 5.
All right. And has he legitimated any of these children?
Yes.
How did he do that?
3 is biologically his.
Okay, so you don't know what the word legitimate means.
Can you explain in other words,
If
please?
if if you and Mr. Craig have children and you are not married, then the only person who has rights over the children is you. Mr. Craig has no rights to visitation, custody, or anything with regards to the children. He would need to file a separate case in the Superior Court. It's called a legitimation case, where he can then establish himself as the rightful father of the children, as well as get joint custody and joint visitation rights. Otherwise, you hold the sole decision as to whether Mr. Craig even has any contact with the children.
Okay.
Thank you. All right, Miss Pinto, any thing to add?
Yes, Judge. Mr. Craig is 44 years old. He's lived in Atlanta for about 10 years. He does have 4 children who live here. And he has a good job working at an Amazon warehouse. He's been there for 2 years. So he has very strong ties to the community. He has no convictions, per the pretrial report, no violent convictions, of course. No failures to appear ever. Pretrial recommended a signature bond through the jail. And I just to note the defense side, it's my understanding that Ms. Pinckney was experiencing some type of serious mental health crisis. Mr. Craig was trying to help her. I know that the warrant alleges there was no evidence that he had been stabbed, except it also alleges that there were fresh stab wounds found on his body. So I think, there's definitely, something to look into. And I understand he has previous arrests, but has stated no convictions. I would ask for a signature bond, and given that they live together and share children, that he be allowed no violent contact with Miss Pinckney, which is what I understand to also be her request, and nothing further.
Miss Pinto, is it your client's position that he has been allegedly stabbed with a sharp instrument by Lakeithia Pinckney?
Judge, that's what the warrant says. Yes, that.
No, I'm asking you, your interview with your client, is that the allegation? I've already read.
Not that he was intentionally stabbed. No.
Not intentionally stabbed.
Yes, Judge.
Well, that leaves room for a lot of interpretation. Okay. For count 1 and count 2, it's going to be $3,000 each. That's going to be a $6,000 signature bond through pretrial services level 3. He will report to pretrial once a week. He will undergo a domestic violence intervention program, and he must enroll in that program within 30 days of being released. He's to have no further violent contact with Miss Pinckney. Miss Pinckney, are you comfortable with Mr. Craig living with you?
Yes, ma'am.
All right. No further violent contact, and he may share the same residence with Miss Pinckney. As I said, Miss Pinckney, if Mr. Craig would like to have any kind, if you want Mr. Craig to have any kind of rights over the 4 children, he should file a legitimation action in the appropriate superior court. Otherwise, any decision regarding the children is completely with you and you only. Understood?
Yes, ma'am.
All right. No further violent contact. In other words, there cannot be any future physical or verbal altercation with Miss Pinckney. Otherwise, if there is and the police get involved, then Mr. Craig will be the one arrested, and his bond will be converted to either a $6,000 cash bond or a $6,000 surety bond. No illegal drugs, no alcohol, and no weapons and no firearms. Thank you.
Number 10, 2.
This is State versus Rashad Hughes, accused of criminal trespass from February 15th, 2025. Accusation 25 CR 868Y. Mr. Hughes, you've been advised of your rights and your attorney is Ms. Pinto. Any priors, Mr. Howard?
14 on probation, not a card for trespass. Couple of trespass arrests from last year, 2023 trespass obstruction conviction, 2023 FTA, battery conviction 2016. He was here last week and he was rewarded with the pretrial signature bond level 2. I'm about to revoke that. I think it was 2,000, 2,500, something like that. Nothing further.
Thank you. Ms. Allen, what's the bond recommendation from the state?
Your Honor, we're asking for this bond in this case to be a surety bond to stay away from the location. This week, it is the BP gas station at 4350 Jonesboro Road, and no drugs, alcohol, or weapons. We requested a social worker visit last week on the 13th when he came through, but he was released before somebody could meet with him. He has an open case 25 CR 0000772Y, which is another location on Jonesboro Road, the Walgreens. And this is a bond order signed by Judge Morrow. Thank you.
Thank you.
He just went back to another location, I'm sorry, on the 15th. So he was released on the 13th, back on the 15th, arrested and bound over to us again by Union City.
Okay. Ms. Pinto?
Thank you, Judge. Mr. Hughes is 32 years old. He's lived in Atlanta for about 20 years. His parents are also here in Georgia. He has one child who's 12 years old that resides with him. His mother is currently watching her. He did some college, attending trade school. He now works at Crystal. He also cuts hair and works as a referee for a league, rec league. His bond is currently $1,000. He has no money to pay bond. I understand what pretrial is saying, but all he can afford is a signature bond, and so that's what we would ask for, Judge.
All right.
And Your Honor, I would note that his prior conviction here for criminal trespass is related to the address at 6298 Mallory Ridge in Union City. That's his mother's residence and the residence that he has provided as his home. And she went through an eviction process in 2022 during that case. So the state has some concerns about the validity of the claim that that's his residence, because he keeps getting picked up in Union City criminally trespassing all along Jonesboro Road.
Oh dear. All right. Mr. Hughes, yes, you were given a signature bond some time ago by Judge Morrow. Unfortunately, one of the requirements of a signature bond is that you cannot get arrested again, but you did. So that $2,000 signature bond you received in the prior case is surrendered. So now it is a $2,000 surety bond. But this new case is a $1,000 surety bond. So we're going to reset both your cases to March 4th. You are to stay 200 yards away from the BP gas station on Jonesboro Road. And we will reset this new case along with 25 CR 0000772Y. Please unmute courtroom 2. Mr. Hughes, you have a right to remain silent. Anything you choose to say can and will be used against you.
Yes, ma'am. So both of the criminal trespass cases are going to get dealt with together on March 4th?
That would be correct.
Okay, and on March 4th, I can plea out and give my time that for both of them?
I don't know what plea offer the state will provide you. They can either provide you a time served or they can make you serve probation. Given your number of cycles, I'm not sure which way the state's inclined to go.
And that can be time served. That'll be, I
don't know. I
will deal with both of them together, both of those charges together, correct?
Yes, they probably will come up with a plea offer and it'll be up to you and your attorney to discuss it.
Okay, thank you.
He knows the routine, folks. So let's see what happens on March 4th. Next case.
Number 11, Jackson.
Miguel Jackson is accused of simple battery family violence from January 28th of this year. Accusation 25 CR 8518. Mr. Jackson, you've been advised of your right. Your attorney is Mr. McLean. Any priors, Mr. Howard?
11. Last arrest was in 2013 for obstruction. It was dismissed.
All right. And Ms. Allen?
Thank you, Your Honor. This defendant has criminal history back into the 90s, but the 2013 arrest is the only thing since 2008. I believe he was charged with possessing a prohibited item while incarcerated in 2008. He's got multiple prior convictions for armed robbery in the 90s. This is an incident from the 28th of January, Your Honor, 2025. This took place at 1 p.m. Around Marietta Street, 20 Marietta Street, specifically apartment A14. Police were called to the location. Actually, yes, the police were called to the location by the victim. Her name is Carolyn Strong. She reports that her live-in boyfriend had assaulted her around 5 a.m. that morning. He struck her in the face, told her he was going to harm her. She took this threat seriously because of his criminal history. That initial report was reviewed by a DV investigator who made contact with Mrs. Strong and obtained a warrant after corroborating that information from her. She had been struck in the right side of her face. The warrant specifically states that she had visible injuries, but follow-up also contradicted that. So we have a simple battery family violence today. We tried to get in touch with Mrs. Strong, but we're unable to so far. We're asking for a $2,000 surety and no contact with Mrs. Strong, no drugs, alcohol, or weapons. I will leave the matter of a stay away up to Your Honor. I'd note that he was arrested on the 16th when he failed to follow the rules about where to take a right there at the intersection of Marietta and Fairley Street. When his information was run, it was seen that he had a warrant. He said he was aware of the warrant, and then his mom came and got his car and parked it in the parking deck there at 20 Marietta Street. So I'm unclear if Mrs. Strong is still living there. Thank you.
Mr. McLean?
Thank you, Your Honor. It may be, I don't know personally, but it may be that Ms. Strong is in Maryland, but I don't know of the permanency of that arrangement. Mr. Johnson is 49. He's from Georgia. His last job was in cleaning homes as part of a business. He did that for 8 months at a firm. Before that, he worked in a law firm as a legal assistant. And we would ask the court to consider as low a bond as possible in this, including a signature bond, as part of our request, Your Honor. Thank you.
Okay. Bond is going to be set at $2,500. It's going to be a signature bond through pretrial services level 1. No further contact with Carolyn Strong, and he's to stay away from the entire apartment complex, including Unit 14A at 20 Marietta Street. He's allowed a one-time visit with a police officer to the location. If it is verified by the police officer, if there's a leasing office or an on-site office that can also verify that Ms. Strong no longer resides at the unit, then he may return to the location. Otherwise, within 30 days, he must update the court with a new mailing address. He's allowed, and in that one-time visit, if she's still living there, then he has 1 hour to retrieve his belongings and his car. Within 30 days of being released, he will enroll in a domestic violence intervention program. This is a series of 26 classes, and you will enroll in those classes at your expense and complete all 26 weekly sessions. No illegal drugs, no alcohol, no weapons, and no firearms. Your next court date will be sent to your current mailing address. So it's either going to be Marietta Street or you'll need to update us with your new address within 30 days of being released. Courtroom 2, please unmute. Yes, sir.
Your Honor, that is also my address. My name is on the lease. Also, when on the deed also.
Does she live there?
No, she stays right now in Baltimore, Maryland, in another home.
Well, if she is also an owner of the property, she has a right to return to that location. And if she does that, then you would need to vacate until further order of the court.
Okay, up until now, we both have been living there. Even after this incident, we both still stay in the place.
If she comes back to the apartment, then you will have to vacate. You are not allowed to stay in the same place with her.
Yeah.
But right now, if you go back with a police officer and she's not living there, you can live there. But the minute she shows up at the front door, you need to pack up your stuff and leave.
Okay.
And then update us with your new address.
All right, thank you.
And don't forget to report to pretrial once a month and enroll in those classes within 30 days.
All right, thank you.
Francois, did you have another case?
Yes, I do. Judge, this is going to be Mitchell Kamaya, but she needs to be interviewed by McLean.
Okay. We're going to put Mr. McLean and you in a breakout session very soon. Let me just find out who's in courtroom 2. Who's in courtroom 2?
William Jared.
No, let me do this. 12, Jared.
Jared, is that your client, Mr. McLean, or Miss Pintos?
He is, Your Honor. He's my client.
Okay.
I can do the interview, Judge.
All the rest of the guys I have are from Mr. McLean.
All right, Mr. McLean, any objection to Miss Pinto taking over the Miss Kamaya's case?
Certainly not. Do you have the paperwork?
Is she a bindover?
She's one of the bindovers, so it's accessible through Odyssey. It'll take you a minute.
Okay, I can find it.
I mean, through email. I mean, Outlook, not Odyssey. Sorry.
All right.
It's actually an Odyssey. Also, it's actually also.
Okay, Miss Lewis, if you could place Fulton ACDC and PD Luisa Pinto in a breakout, please. Thank you.
Thank you, Judge.
Thank you. All right, we are addressing William Jarrett, case number 25 CR 856Y, accused of criminal trespass causing damage to property and criminal trespass, well, 2 counts of trespass causing damage to property from February 18th, 2025. Mr. Jarrett, you've been advised of your right to remain silent. Your attorney is Mr. McLean, and I understand this is his first arrest. Ms. Allen, anything to add?
Your Honor, this is a 17-year-old young man. This is his first arrest. The incident here is from the 18th of February, so yesterday at about 8:30 p.m. The victims in this case are his mother and his stepfather. This is damaging property in the residence where he lives. When police arrived on scene, they saw multiple holes in the wall, a dented wooden front door, and a computer monitor that the defendant had in anger thrown over the balcony and destroyed. When police spoke to mom and dad, they reported that there's an ongoing diagnosis and refusal to take medication and be compliant. There are concerns for safety. This is a escalating issue. We have spoken to mom, Krista, and stepdad, Peter, who are here on the Zoom. We're asking for a $4,000 SOB through pretrial, no drugs, alcohol, or weapons other than those he's prescribed, to be medication compliant, no violent contact, and we'd ask for a curfew if the court could inquire about how this young man spends his day. That might also help. And if you'd sound for the Thompsons, thank you.
All right, Ms. Krista Thompson and Mr. Peter Thompson, which of you like to testify first?
I will.
All right, please raise your right hand. Right hand?
Oh.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Judge.
All right. Where does he go to school?
He just came back from Colorado, so he's not enrolled, and we are currently looking to enroll him into a GED program.
Okay.
He's been in town for 1
homeschooling?
week. I'm sorry.
Is that homeschooled?
What was that?
Are you looking for a homeschooling program?
No, we are looking to enroll him through one of the local universities through their GED program.
All right. And does William go to any specific healthcare provider for ongoing treatment?
He does not have established provider here in Atlanta since he just got back. We do have referrals.
Okay.
From his recent inpatient visit.
All right. And how do you feel about him being in the same home with you?
He's never shown physical violence before towards us. With him being 17.
So just to clarify, he's only been here for a week?
Yes.
So no physical violence in the last week since he's been here, except for this incident?
Yes. Prior, when he was living with us full time, there's been no physical violence. He has had outbursts. But I do feel comfortable having him come home. I would feel more comfortable if he was willing to take his prescribed medications.
Quorum 2, please unmute.
Tell me what was that?
I'm sorry, we can't hear you, young man. You remember what I said, right? About the right to remain silent? Anything you say can be used against you.
My medications, and I've done took my medications. She just hasn't told me where they are and when to take them. And
Oh, I see. So mommy has to tell you where your medicine is?
how am I supposed to take it if I don't know where it is?
All right, then I'll make sure that she knows and that she lets you know. Okay. Mr. Thompson, did you want to add to this proceeding?
If you have any questions for me, I'm happy to answer them.
All right. As Mrs. Thompson's already indicated, that you all need to establish some kind of referral program. And well, you are on site seeing the alleged damage. Do you feel comfortable with William being back in the home with you and your wife?
Yes, as long as he's taking the steps to address the issues that caused last night.
I'm sorry.
I have no guarantee of that. I don't live with William. You both do.
Yeah.
So either that or he'll end up back in jail. So y'all need to let me know if y'all are comfortable with him. Otherwise, he'll sit in Rice Street Jail. I don't know if anybody finds more comfortable.
We're comfortable.
We're comfortable with him coming home.
Oh, thank you. Did you have any questions, Miss Allen? Okay.
We would just ask that any order of the court at this point address the need to have an evaluation and follow through with treatment and medication and no violent contact.
All right.
Thank you.
Mr. McLean, anything else to add?
Your Honor, I believe the college or university level institution that would have a GED class available would be that Gwinnett Tech location on Old Milton Parkway across from the Container Store and the Chick-fil-A there. Yeah. He tends to be a mechanic and he already fixes engines on the side a little bit whenever he can, small engines, and hopes to job in that area. And he would pursue trade school matters as well as the GED, Your Honor. He was just in Colorado, I believe, for just a year. So he's substantially lived in Georgia all his life, except for that year leading up to about a week ago. Mr. Jarrett himself believes that this is a one-off incident. He does not believe that he will have any problem living with his parents and having this this level of matter repeat.
Okay. William, so everybody keeps reminding me that you are 17 years old, and I guess that might be some kind of code for, he shouldn't be sitting in jail. He should be out of jail because he's so young. But trust me, in my experience, if you're 17-year-old, you are old enough to be arrested and charged with a felony, and you're old enough to be charged with a misdemeanor crime. And I'm not one of those people who will release an individual just because he's 17 years old. I have no problem keeping you at the Fulton County Jail. None at all.
Yes, ma'am.
All right. So you've already done a scenic tour of the jail. And if you're comfortable there, you're more than welcome to stay there. You just need to let me know whether you'd like to stay at the jail.
I don't mind, but at the same time,
You really don't mind staying at the jail?
it's all right. I mean, I get food here.
Oh,
But I would just like the
Ms.
food.
Thompson, he seems to be quite comfortable there. How do you feel about it?
I mean, he asked to go there last night. That makes me very sad.
Dude, I want to get CPS involved because you hit me and I hit the wall, and then you didn't hit me, you grabbed me, and then I hit the wall because I was trying to get you off me. And then
Young man, you're actually in front of a prosecutor. We are allowed to hit our children as long as we don't leave marks. So just give you some information right there. We're going to ask for a cash bond, Your Honor. Thank you.
Wait, hey, hold up. Look at the side right here. You see them marks on my side?
Free to go. Thank you. He's free to go. Yeah.
What was the bond amount?
It's going to be $1,000 surety bond on each count, and that's going to be a $2,000 surety bond. Next court date is March 4th. No violent contact with Krista Thompson, no violent contact with Peter Thompson. Mr. and Mrs. Thompson, if you decide that you want to release your child from the jail, it's a $2,000 surety bond. You can go through a bonding company, you can put up cash. It's entirely up to you. But no violent contact with either one of you. He can return to the home that he shares with you, or you are more than welcome to kick him out. That's entirely up to the two of you. But once he's released on bond, he will be required to undergo an alcohol and drug an MH or BH evaluation and submit himself to any treatment and medication that the evaluator requires. MH would be mental health and BH would be behavioral health. No illegal drugs, no alcohol, and no weapons. And his next court date, if you decide not to bond him out, then his next court date will be March 4th at 9 a.m. Same environment through Zoom proceeding. All right. Right now, you both are the ones with the best knowledge of how to move forward with him, and it's entirely up to both of you.
Okay.
All right. Please keep in mind that if he violates any of the bond conditions or if he gets arrested again, he could be back in jail with no bond. Thank you.
Thank you, Your Honor.
Thank you.
Number 13, Mr. Martin.
This is Darius Martin, accused of simple battery family violence from December 21st of last year, case number 25 CR 867J. Mr. Martin, you've been advised of your right to remain silent. Your attorney is Mr. McLean. And any priors, Mr. Howard?
13, 2017 DUI conviction, 2012 FTA and drug trafficking. He got a lot of history out of Alabama.
Recent history?
I didn't break it down. I just went through Georgia and Alabama. He got 2010 and 11 FTAs.
Okay. Thank you. Ms. Allen?
Your Honor, this is an incident that was reported in December of 2024. The victim in this case, her name is London Clark, and she shares a child with the defendant. They have an ongoing legitimation action and custody action. It appears that she, in 2024, moved out of the state, and they have been going back and forth with transfer of custody of the child that they share, who's about 7 years old. Mrs. Clark went into the precinct on the 21st of December and reported that while doing the exchange of their child at the Zaxby's at 3770 Princeton Lakes Parkway, she and the defendant argued. The exchange was supposed to happen the day before. Mr. Martin was handing over the child to her, Mrs. Clark. This occurred at the Zaxby's. He became angry, and while she was holding the child after they'd done the initial transfer of custody, she said that he tried to grab the child from her. This caused her to fall down. He then put his knee in her back and held her on the ground, and that employees there at the location had to intervene. Follow-up was done with her after the initial report with a DV investigator with APD. She reported that this had happened. She identified the defendant for police, and they obtained a warrant January the 7th of this year, Your Honor. There is a temporary parenting agreement and custody agreement in place, and we did speak with Mrs. Clark today. She says that she wants to continue to have contact with no violence, and they're going to continue to work forward with their parenting plan to share the child that they have, that they're not in a relationship any longer. So we're asking for a $2,000 surety, Your Honor, no violent contact, no drugs, alcohol, or weapons, and to abide by any orders of the court related to legitimation and custody of that child. And if you'd sound for Mrs. Clark in case she was able to join us.
London Clark, I see someone called Vivian's iPhone who's appeared. I don't know if she's involved in this case. Vivian's iPhone, are you involved in this case? No, then close your video out. Close your video.
I'm here for Kamaya.
Then close your video. We're not addressing Kamaya yet. All right. Well, I didn't. Okay, good. Mr. McLean?
Your Honor, I spoke with his domestic matters attorney who could not take part in this proceeding today because of a prior court commitment. The arrangement has to do with, as the state describes, I believe he's got primary or something physical custody. I've not seen any court papers, so I'm just speaking by hearsay, Your Honor. He has some college. He's done 2 years of computer work at Alabama A&M. He is a property manager full-time for the last 8 years. For the last 2.5 years, he's also utilized part-time his real estate license.
Okay.
He asked the court to consider giving him a signature bond. In this situation, he does believe that they can continue to work together on this custody matter with no problems. He is both from Alabama and Georgia, and of course he's 35, and I don't have any further biographical information, but he does ask the court to allow a signature bond if possible.
I have an address in Union City. Is that his current address, or does he reside in Alabama?
The Union Point place address is current, Your Honor. I noticed place of birth, Anniston, Georgia. There's no such thing. We know that's in Alabama.
All right. So he resides in Alabama?
No, he lives in Union City.
Okay.
Union Place, as shown on the 3 card.
All right. Thank you. Bond is set at $3,000. It's going to be a signature bond through pretrial services, level 2. No further violent contact with London Clark, and to comply with all visitation, parenting plans, and all restrictions imposed in his ongoing domestic case. He's to report to pretrial twice a month. He will enroll in a domestic violence intervention program within 30 days of being released on bond. This is a series of 26 classes, and he'll be required to enroll and pay for those classes out of his own pocket. He's not allowed to skip or miss any of those classes. No illegal drugs, no alcohol, no weapons, and no firearms. He will be subject to random screens for drugs and alcohol. If you change your address, Mr. Martin, make sure that you update the court of your change of address immediately. If you get arrested again for anything else, your $3,000 signature bond will be surrendered. Thank you.
Judge, we're ready for Kamaya Mitchell.
Okay. Maya Mitchell is accused of willful obstruction of a law enforcement officer and criminal trespass. Incident date is February 14th, 2025. Case number 25CR870E. Ms. Mitchell, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Pinto. This is her first arrest, but she appears to be a resident of Texas. Ms. Allen, what's the state recommendation?
We're asking for $1,000 SOB, Your Honor, and no drugs, alcohol, weapons, and to stay away from the Quick Trip at 4745 State Route 138 in Union City. I did note that her address appears to be out of state. She's got no emergency contact. At the jail that was mentioned in this report, she didn't make any statements to officers about why she's here in Georgia. So there's some questions. Police responded to a call about someone refusing to leave at that location at the Quick Trip at about 7:30 p.m. on the 14th, which was Friday. The defendant was found in a lady's bathroom. There were multiple book bags inside a stall on the floor. When officers asked if she was all right, she came out of the stall and said she was fine and gathered her things and went to leave. When officers asked her to provide information about her identity and show some ID, she refused multiple times. She then walked outside, refusing the verbal directives of officers, and a major showed up from Union City and tried to interact with this young woman. And again, she refused to identify herself. She was eventually identified through the fingerprinting process. And so there were some concerns about what's going on with this young woman.
Someone called Vivian. Did you want to contribute to this proceeding?
Yes, I'm her mother, and we reside in Houston.
Right hand, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
How old is Kamaya?
She's 22.
And does she live with you here in Georgia or in Alabama? Excuse me, Texas.
In Texas.
Are you a resident there?
Yes, ma'am.
And is she visiting or studying, or what's she doing in Georgia?
Honestly, I don't have any idea. One day she just called and said that she was in Atlanta. She don't have any residents down there. I mean, any.
Could you lower your device? Okay.
She doesn't have any family. We don't have any family in Georgia, and I've been asking her to come home. She don't have anywhere to go. So if you guys give her a bond, I will have to drive down there to bond her out, and I just don't know what to do. So.
Well, my concern is where she's living.
Yeah, that's my concern also.
Okay. So Kamaya Mitchell, I have only a Houston, Texas. Miss Mitchell, do you have a local address?
Yes. So when I moved out here, I was staying with a friend, and then I met another friend. He had Airbnb, and he told me.
I want to know whether you have a local address. That's all.
Yeah, I have the address, but that's not where I was living.
Okay.
So I was there, and then I started working overnight, and then during the day, I just started having rooms, and then I met another friend. He was from Houston.
So you're living with friends and you don't have an address of your own?
May I speak?
Yes, Miss Vivian.
Vivian. Kamaya doesn't have any residents down there. From what I'm getting, that when she do call me, it's like she's meeting people and they're letting her stay with them. So I'm concerned about Kamaya's safety. The best place for her to be is in Houston, Texas, with all her family, her siblings. She decided to go out there. She don't know anyone out there.
All right. Thank you. Thank you, Miss Vivian. Miss Pinto, maybe. Go ahead.
Yes, thank you, Judge. Ms. Mitchell, 22 years old. She reports that she moved to Atlanta about 2 months ago and has been staying with friends. She did recently get a job working at a club. This is her first arrest. We would echo the state's request for a signature bond. She is able to comply with the stay away from that Quick Trip location. So given that she has no history, we would ask for the signature bond.
And does she have a current local address?
Well, Judge, we left the Houston address because that's the permanent address. I informed her once she has a permanent Atlanta address, she will need to update it with the state court clerk to ensure that she gets her court notices.
Okay. On count 1 is a 500 surety. On count 2 is a 500 surety. Her current bond is 1,000. It is a surety bond to stay away from the QT gas station at 4775 State Route 138 in Union City. Ms. Mitchell, hopefully you can reach out to your friend, and within 30 days of bonding out, make sure you update the court with your new mailing address and your phone number and your email, because if we don't have a good address and you don't show up for court, then another warrant will be issued for your arrest.
So yeah, I didn't. So never mind.
In order to be released, you can either come up with $1,000 and you can put that up as a cash bond, or you can put up a surety bond, which means you go through a bonding company and they charge between 10 to 15%.
So I thought I would get like a signature line.
Unfortunately, you have no ties with Georgia, and my concern is that we won't be able to reach you. Thank you. Make sure you do not return to the QT gas station. Next case, please.
Number 19 Wood.
Oh, and next court date is March 4th, unless she makes bond. Ms. Vivian, do you have any questions?
No, ma'am. We'll just wait till March 4th because if she gets out, she don't have anywhere to go until I come down there and bond her out. So
You can do that today or tomorrow. Okay, thank you.
all right.
I'm sorry, courtroom 2, who do we have?
Wood, position number 19.
Woods, okay, thank you. Monte Woods is accused of simple battery from November 13th of 2024, accusation 25 CR 855F. Mr. Woods, you've been advised of your right to remain silent, and your attorney is going to be Mr. McLean. Any prize, Mr. Howard?
On probation out of Henry County for burglary. He's wanted out of Henry County on a probation violation. Also on probation for criminal damage to property. Open case out of Cherokee County for a fray. 2019 burglary, possession of tools, trespass conviction. 2018, 2015 probation. 2015 terrorist threats conviction.
Ms. Allen?
Thank you, Your Honor. There's a little bit of a lack of information here, or I would say investigation. I'm hoping this is an ongoing investigation. This is an incident from November the 13th of 2024. This young man was arrested after the fact and has been in Cherokee County and will be going to his next location in Henry County after this. Police responded to the report of an assault at 3198 Washington Road in East Point, which they discovered is an address associated with this defendant and his brother, who was on the first appearance calendar today. His name is Cedric Woods. It was about 1 a.m. The warrants and the documents we have report that when police arrived, they observed this defendant striking the young woman, Lemetria Trammell, in the face as they sat in the rear of a vehicle that belongs to his brother. He fled on foot and then was apprehended. He fled specifically when he saw officers. When police spoke to Mrs. Trammell, she said that she met him on Facebook and that he'd come to her address to pick her up. She told him she was having problems with her vehicle and she needed to deliver for DoorDash and asked if he would mind driving her to make some deliveries. He said, not a problem. And they went outside and got in his vehicle. At that point, she realized the driver of the vehicle was a different person and it was this defendant's brother. The victim, Mrs. Trammell, reported that they went and picked up some food that she needed to deliver, and then they started to drive in an area that was not where she needed to go and was away from her home. She reported it was across town. So she voiced her concern and asked to go home, that they refused to take her home. The young man driving was Cedric Woods, the brother, and this defendant was in the back seat or the passenger seat. I'm not sure. When they drove to the location that this incident happened on Washington Road, the driver, Cedric Woods, got out of the vehicle and went inside, and that's when the victim was left alone with this young man in front of you that she met on Facebook. She reported that she told Mr. Woods that she needed to go home and to go inside and get his brother so that they could get her home. She said he refused and began yelling at her and struck her in the face with a plastic bottle of cranberry juice. And that's when she called 911. So based on the logic, she was hit multiple times because police observed the defendant striking her with his fist when they arrived on scene before he fled. Police spoke to Cedric Woods, who said, yep, we picked her up. We drove her and took her to one of her DoorDash deliveries. And then I went home. I didn't know what was going on. I didn't see anything. The defendant in front of you claimed that in the vehicle, she started arguing with him and threatening to damage his vehicle. And that's when the victim assaulted him, and he was only fighting back. So there's some concerns here, Your Honor, about the circumstances that gave rise to a young woman being not in her home, in the back of a vehicle, asking to be taken home, and then being assaulted multiple times, and this defendant being witnessed assaulting her. There's a serious criminal history for this defendant. He's got multiple felony convictions for burglaries and thefts and criminal damage to property. And his brother does as well, and he's on the felony docket today. We have tried to get in touch with the victim in this case, but we haven't been successful yet. We'll continue those efforts. I've also reached out to the investigator in this case to ask about follow-up information. We're asking for a $2,000 surety, Your Honor. No contact with the victim in this case. Again, her name's Lametria. That's Lametria. Last name is Trammell, Trammell. We'd like no contact with her, and no drugs, alcohol, or weapons.
Okay. Mr. McLean?
Yes, Your Honor. What the state has brought up makes me realize there's a housekeeping matter here, but a rather important one. If we could briefly go into breakout with the state, myself, and Your Honor, I'll bring that up.
Okay. Before I do that, Courtroom 2, what's the situation with Position 2, Edward Bowden?
Posted bond and Mr. Gray is a medical reset.
All right, so this is the last case then?
Yes, ma'am.
Okay, Position 7 is a medical reset to February 20th. All right. Okay, we'll be right with you all. Ms. Lewis, if you could place, with the exception of Courtroom 2, myself, Ms. Allen, and Mr. McLean in the breakout, please. And Ms. Bridgewater. All right, going back to Mr. Woods. Mr. Woods, so presently, based on the discovery that the co-defendant, Cedric Woods, has been addressed in Superior Court of Fulton County, there is a question as to whether he was represented by the Public Defender's Office or not. So presently, the Public Defender's Office of Fulton County will not be representing you until they verify that they don't have any conflicts. Then of course they will continue to represent you. If it turns out that the Public Defender's Office is representing Cedric Woods, then we would need to appoint a conflict attorney to represent you. And we can reach out to either Mr. Dennis Murphy or Ms. Maureen McLeod to represent you. Presently, your bond is going to be $1,000. It's going to be a surety bond on one count of simple battery. No further contact with Lametria Trammell. No illegal drugs, no alcohol, and no weapons. And you are to be released unless there are any pending holds. So presently, it looks like you may have a Henry County hold, but I'm just going to put the language unless there are any pending holds. So if it turns out that once you bond out, there are no holds, then you can bond out. But right now it's $1,000 surety, and your next court date is March 4th. And
Your Honor, Mr. Cedric Woods was on first appearance today for a probation violation warrant. He was not arrested related to these facts in this case.
Okay, but was he represented by PD or by?
I'm not sure. Let me see.
We can always confirm that down the road. Mr. McLean can call his office to see who represented Cedric Woods on the probation matter.
Thank
All
you.
right, Mr. Woods, we will see you on March 4th unless you make bond or unless you're transferred to another jurisdiction. Thank you. Okay, so position number 1, Cortez Banks was a 2,500 signature bond to pretrial, level 1 with the FBIT requirement. Position 2, Bowden was released. Position 3, Burke, and that's going to be a $1,000 surety bond, reset March 4th. Position 4, Craig is going to be a $6,000 signature bond to pretrial, level 3 with an FBIT requirement. 5, Davis is a $1,000 surety, reset March 4th. 6, Ellis Wallace is a $5,000 signature bond to pretrial, level 3 for judge. And was that correct?
Yes.
Okay. And then position 7, Gray is reset to February 20th, the C calendar at 2 p.m. This is going to be a medical reset, so no Riverside issues. Position 8, 2,500 signature bonds for pretrial, level 1, further notice. 9, Horde is a $600 surety bond, reset March 4th. 10, Hughes is a $1,000 surety bond, reset March 4th. 11, Jackson is a 2,500 signature bond to pretrial, level 1, with the FBIT requirement. 12, Jarrett is a $2,000 surety bond, reset date March 4th. Position 13, Martin is a $3,000 signature bond to pretrial with an FBIT requirement. Position 14
What
is
level is that, Your Honor?
level 1.
I got level 2. That was level 1.
I want to, it looks like 1 over here.
This
This is the one with London Clark, right?
I don't know. State, what you got? Level 1 or 2? Judge, what you want? Level 1 or 2?
This is
Martin.
yes, I didn't write down the level.
If I can't make up my handwriting, let's go out with 1.
Okay.
This is the one with the Alabama and the Georgia side.
Okay, so it was 2 then, yeah. So okay, level 1 now. Okay, thank you.
But he's got an FBIT requirement, so.
Okay.
Position 14, McPhee is a 2,500 signature bond through pretrial, and I can read that, level 1 with the FBIT requirement and no violent contact. Position 15, Mims is a $4,000 split bond, reset date March 4th.
That's level 3, right?
That's level 3, correct.
Yes.
Bond to pretrial level 3 with random screens. 16, Mitchell, and that's a $1,000 surety bond, reset date March 4th. 17, Ramirez Dietrich is a 2,500 signature bond for pretrial level 1 with an FBIP requirement and an ADET and random screens. Position 18, Williams is a $5,000 surety bond, reset date March 4th. And 19, Woods is a $1,000 surety bond with a reset date of March 4th to be released on bond unless there are any pending holds. You try that language. Okay, any corrections to be made?
I think that's it.
All right, folks, you all have a good afternoon. We'll see you tomorrow. Take care.
Take care, everyone.
You on for tomorrow?
No, I will be on for Friday and Saturday.
Okay.